Uh, First, I want to say the views that I'm about to express are my own. I'd also note that I'm a former president of the Association of Criminal Defense Lawyers. I am now serving my 20th and last term on the New Jersey Supreme Court. In the 25 years before I became a judge, I tried approximately 60 cases before juries. As a prosecutor, as a criminal defense lawyer, as a civil plaintiff's lawyer, and as a civil defense attorney. In all that time, I never met an attorney interested in picking a fair jury. Every attorney I knew wanted to use peremptory challenges to select a jury that would favor his or her case. Every attorney wanted a partial, not an impartial jury. The theory goes that through the clash of each side's parochial interests as expressed through the use of peremptory challenges, a fair jury will emerge. One argument is that the unconscious biases of each side will cancel each other out. Is that a sensible way to select a jury? Now, my views about peremptory challenges have evolved over 45 years as I've tried to imagine a more perfect system of justice. Let me say this. I am in favor of expanding the voir dire process. I am in favor of granting for-cause challenges liberally. For-cause challenges are on the record. The reasons for removal are articulated. And an attorney's unconscious biases may be aired and revealed in the process, which is precisely what occurred in the Andahar case. If the prosecutor had merely exercised a peremptory challenge in Andahar, we would never have known the real reason why the prosecutor sought the juror's removal. Peremptory challenges lack transparency. There is no accountability. Attorneys make decisions in the dark recesses of their mind. We would never permit a judge to remove a juror without giving reasons. I know how attorneys decide on using peremptory challenges. I've been there. Often it is by the seat of your pants in the quick-paced hurly-burly of removing one juror and seating another juror. The basis for the exercise of peremptory challenges many times is based on instinct, intuition, generalizations, and stereotyping. And that is where inherent biases and prejudice find refuge. We have matured and evolved as a society. We do not tolerate discrimination in the workplace on the basis of race or color or nationality or religion, gender, sexual orientation, age, or disability. Yet that type of discrimination can find a safe harbor in a peremptory challenge. How will we know whether a person is being removed from a jury because of his color or nationality, or because she speaks with an accent, or wears a head garb, or because he or she is Jewish or Muslim? Peremptory challenges hide the truth. Peremptory challenges have an ancient lineage, and it has the force of tradition. But our growing recognition of the importance of civil rights is a more recent origin. Peremptory challenges may conflict with the ideal of civil rights. You may ask yourselves whether peremptory challenges are really a guarantee to a fair and impartial jury. Peremptory challenges permit an attorney to calculate whether there are too many Blacks or whites or Hispanics, men or women, Jews or Muslims on a jury. Justice Thurgood Marshall, in his concurrence in Batson, believed that only banning peremptory challenges entirely would end discrimination in the jury selection process. He knew firsthand about the misuse of peremptory challenges because in his time, he witnessed peremptory challenges used to remove every African-American from a jury panel. Yes, the use of peremptory challenges today is more subtle, but is the removal of a single person on the basis of race acceptable today? We know that an African-American profiled in an automobile stop may bear some intangible scar from the abuse of authority. What about a Black person or a religious person wearing a head covering or some other person in a protected class who believes that he or she has been unfairly removed as a juror? In a courthouse, in the very seat of justice, what impression will that leave? I will conclude by paraphrasing some words expressed by Benjamin Franklin when he last addressed the Constitutional Convention in 1787. He told his fellow delegates that in his long life, he often had occasion to change a long-held opinion in light of better information and fuller consideration. Understanding that his own judgment might be imperfect, Franklin said that he developed a better respect for listening to the viewpoints of others. And in that spirit, he asked his fellow delegates to doubt a little bit about their own infallibility and to keep an open mind to the views expressed by the other delegates in the convention. And I ask everyone here to do the same as I will. Although few may be prepared to entirely eliminate peremptory challenges as proposed by Justice Marshall, let us all remain open-minded about limiting them. Thank you.